For the record, Your Honour, speech to the initial SG counsel instructed by the Office of Legal Aid Queensland. I appear on behalf of the applicant, Mr. Ike. He has been charged with 84 charges of break and enter and 1 charge of stealing. This application, Your Honour, has been brought forward pursuant to Section 590AA of the Queensland Criminal Code in relation to having the admissions made by the applicant excluded under Section 130 of the Queensland Evidence Act. By way of a background, Your Honour, the applicant was 14 years of age at the time of offending. He was Torres Strait Islander national. Police located him at a residence in which break and enter had been reported. He made admissions in relation to that offence. Police never prior to questioning cautioned him in relation to his rights. Police then drove around the surrounding suburbs, identifying other homes in which the same offence had occurred. Police then obtained from the applicant admissions in relation to these offences. He was then, Your Honour, finally taken back to police headquarters and questioned further in relation to these offences. Your Honour, it'll be my ultimate submission that the treatment and the questioning of the applicant by police breached a number of provisions under the certain legislations in which I will mention to Your Honour in my submissions, and as such should be excluded as evidence under Section 130 of the Queensland Evidence Act. For the reasons, Your Honour, prior to being questioned, it was clear that police identified my client as a juvenile pursuant to Schedule 4 of the Youth Justice Act, and as such, under Section 421, subsection 2 of the Police Powers and Responsibilities Act, police ought to have sought a support person to speak with the applicant or have one present during questioning the applicant. Your Honour, this simply didn't occur. Police never arranged for this. It wasn't until he was taken back to the police station after making further admissions in the back of a police car, in which he was afforded this right to speak with a support person. However, Your Honour, my client instructs me that they were only given a mere 5 minutes to speak. As such, the only advice that was given by the support person was simply just make sure you answer the questions asked by police, okay? Your Honour, it's my submission that this just simply isn't acceptable in this day and age. The applicant should have been allowed additional time to speak with the support person, and the advice provided was simply inadequate in itself. As such, the police have breached a number of provisions under the Police Powers and Responsibilities Act. Additional to this, Your Honour, subsequent to my client's appearance, it's clear he's of Torres Strait Islander descent. Therefore, police, pursuant to Section 420, subsection 2 of the Police Powers and Responsibilities Act, should have sought that a legal representative from Legal Aid Queensland or ATSLs should have been arranged for my client, or even such, just simply contact those officers and advise to my client that this has been done on his behalf. You know, from the evidence provided by the Crown, this simply didn't occur, and it's simply unsatisfactory. These strict legislative requirements have been breached, and as such, the evidence ought to be excluded. At this time, Your Honour, I asked to draw your attention to the section of the court brief in respect to the admissions made by the applicant in the back of the police car. I've walked Your Honour through this very briefly. Pursuant to Section 25, Your Honour, as a Torres Strait Islander person, this is Section 25 of the Police Powers and Responsibilities Regulation, Your Honour, police ought to have ascertained the level of understanding of the offences the applicant was making, and also, Your Honour, in relation to his capacity to ask the questions. This never occurred, Your Honour. The questions police were required to ask were, do you understand relative English? Do you understand the charge of break and enter? As they are serious, indictable offences, Your Honour. As such, police have, once again, breached a number of provisions under the subsequent Act. In addition to these breaches, Your Honour, police also at no time informed the applicant of his right to silence, nor did they inform him in relation to, as I've mentioned, the indictable offences. These fall under Section 26.4 and Section 22 of Schedule 9 of the Police Powers and Responsibilities Act. Though, Your Honour, of relevance and most worrying in my opinion, Your Honour, there are no written or electronic statements of the admissions made by the applicant. There is no way for my office or the solicitor instructing me, Your Honour, to contest any of the admissions because they simply don't exist. The only way they exist is in police statements. Your Honour, Section 436 of the Police Powers and Responsibilities Act provides that admissions must be recorded in some format. It's just unacceptable, Your Honour, and as such, police have breached this provision as well. And as such, again, sorry, Your Honour, the Crown holds no actual evidence that these admissions actually occurred. It's not contested that the applicant made these admissions in the back of the police car. However, Section 5E of the Police Powers and Responsibilities Act provides that the purposes of the Act itself is to ensure fairness. And that's in respect to persons who the police officers exercise power under the Act. Your Honour, it's once again abundantly clear that police didn't respect the rights of my client, and therefore fairness was not given. I note that Your Honour holds discretion to exclude evidence in a criminal proceeding under Section 130 of the Queensland Evidence Act, of which it is governed by the principles developed and adopted in the cases of the Queen of Ireland and Bunnings and Cross, which it was highlighted the importance of the desirable goal of bringing a conviction to the wrongdoer, and the undesirable effect of the crucial approval or even encouragement being given to unlawful conduct of those whose task it is to enforce the law. Your Honour, it is my respectful submission that the admissions made by the applicant and obtained by police contravene a number of provisions, as I have mentioned, and as such, the police, due to the police's failure to allow the applicant to speak with a support person, contact the relevant legal organisations such as ATSLs upon the applicant's request, administer the proper precautions to the applicant in relation to his right to silence, or simply record the admissions made by the applicant, Your Honour. In these circumstances, I respectfully submit that these admissions made by the applicant ought to be excluded under Section 130 of the Evidence Act, as to not do such would be illustrate to the public an approval for the actions of police. Your Honour, unless there are further questions, they are my submissions.